This is the Money Hour with your host, Tina Mitchell, on Alternative Talk, AM 1150. Now, back to the show with local mortgage and finance expert, Tina Mitchell.
Welcome back to the Money Hour with your host and mortgage expert, Tina Mitchell, right here on 1150 AM KKNW, the Saturday, October 24th show. I build a network of elite industry professionals each week sharing their knowledge and expertise to my listeners. If you're hearing my show at a different time or day, you are listening to a rebroadcast. To talk with the guest I have in studio today, you can call the show at 1-855-400-1150. Again, 1-855-400-1150 or online at themoneyhour.com. Back in studio again, Glenn Price with Price Farrington Attorneys and Counselors at Law. Glenn, thank you for coming back in studio and visiting me.
Thank you for having me.
Excited to talk to Glenn about estate planning. Before we do that, a little background on Glenn. Educator, graduated of Harvard, the London School of Economics, and Duke Law School, and 39 years in legal practice. Glenn was named a superstar lawyer by Washington Law and Politics magazine and named a top estate planning attorney in 2013 in Seattle Magazine. Glenn has spoken throughout Washington at public and private estate planning events over the past 20 years and works closely with other professional advisors in serving clients' needs in estate, tax, retirement, asset protection, and family wealth planning. So Glenn, let's go ahead and start out with what are some of the biggest estate planning mistakes that you see people making?
Well, where would you like me to start?
The biggest ones.
You know, there's a piece I wrote some time back that narrowed it down to three. The first mistake is failure to plan in the first place.
Yep.
The second mistake is failure to properly implement the plan you have in place. And the third major failure is failure to update that plan. Now, that's kind of a shorthand way of saying those are the three biggest mistakes. But there are a lot of other mistakes people make. They will not coordinate their estate planning. Their wills will not be coordinated with beneficiary designations on IRAs or 401ks or life insurance policies. They'll fail to take advantage of trust planning for children or for folks who need assistance in money management or for asset protection planning. So there are all kinds of potential pitfalls and mistakes in the planning process.
And Glenn, a lot of people may think that estate planning is just about what happens when they die.
Yeah, this is one of the biggest myths and misconceptions because folks conceive of estate planning as being death planning. They tend not to get around to doing it because they go into denial. They know they're never going to die. It doesn't seem relevant to their everyday life. Estate planning is really much more than death planning. It's really lifetime incapacity and disability planning. And then, of course, it's planning for what happens when you're no longer around.
Yes.
But it's that first component, the lifetime planning, that is often overlooked, not implemented. And the will that you have in place doesn't do you any good if you run into problems while you're alive.
So, Glenn, what would be an example of that? Something that's going to come up with someone when they're alive and they don't have their estate plan together. Share a story of how that could really look for someone.
Well, take a small business owner, for example, who doesn't even have a financial power of attorney in place, who has a heart attack and is out of commission recovering for 4 months to 6 months. No one has legal authority to make decisions, to manage the business, to engage in any kind of financial transactions, because something as simple but as powerful as a financial power of attorney was never signed off by this gentleman or this business owner. That's a practical everyday problem with failure to plan.
Yeah, boy, that could definitely be devastating. What about the important documents for estate planning, Glenn? Can you share those with my listeners?
You know, there are 5 basic estate planning documents for starters that everyone should have. First, a death time planning document, be it a will or a revocable living trust. And then there are 4 critically important lifetime planning documents to go with that will. Number 1, a financial power of attorney. Number 2, a healthcare or medical power of attorney. Number 3, a living will, which addresses the life support issue.
Yes.
And number 4, the privacy authorization under HIPAA, which grants access to your private confidential medical information to the limited number of people who you wish to have access to it. Those 5 documents are really, in some form or other, everyone age 18 and over should have.
Wow. So, Glenn, doesn't your will control how your estate will pass on your death?
Your will controls the assets that it controls. There are a number of assets or forms of titling where the will doesn't come into play, and this is a common trap people fall into. Any asset that bears a beneficiary designation, be it a retirement plan, an IRA, a 401k, a 403b, a KEO plan, a life insurance policy, annuities of all different types, these are assets which will pass by operation of law to the designated beneficiary. The will does not govern or control that asset. Another common example of how assets transfer outside of your will is by the form of titling of that asset. Joint tenancy with right of survivorship ownership is a very common form of ownership of a piece of real estate or a checking account or bank account or brokerage account. By operation of law, the surviving joint tenant or tenants automatically come into title, ownership of that asset upon death. Whatever provisions you have in your will regarding how you would like assets to transfer, they do not reach that joint tenancy with right of survivorship asset. So you can undermine your own planning sometimes if you haven't coordinated beneficiary designations with asset titling with the terms of your will.
So, Washington community property, someone may think that this means that their surviving spouse automatically inherit their estate. Can you talk about this?
Yeah, this is a real common myth. The belief that in Washington state, if you are married, the law means automatically that the community property you own at the time of your death, meaning essentially 50% of the estate, automatically must go to the surviving spouse. The reality is that you control your community property. Your community property can be directed to whomever, whatever beneficiaries you wish at the time of your death. Now, under Washington law, the surviving spouse will have a right to a certain amount, a certain dollar value of the decedent's estate under what's called the homestead exemption. Okay. But it's not all that large a figure. So community property is controlled by the decedent in the decedent's planning documents at the time of death. Typically, the surviving spouse is the primary beneficiary, but the law doesn't mandate that that happen.
Got it. Well, I sure better be on mine.
Now, Tina, if you die intestate, if you die without a will or without having done any meaningful estate planning, the default in Washington, of course, is that community property will transfer to the surviving spouse.
Got it. Okay. So, Glenn, do you have any of your clients go, you know what, trust her for just the wealthy people? How would you answer that?
This, again, is one of the most common misconceptions people have. If you're not a Bill Gates or a Steve Ballmer, or for the older generation listening out there, the Rockefellers or Kennedys or DuPonts, that a trust isn't relevant. And really, a trust is a tool that allows assets to be managed, held, protected, and distributed out over time for all kinds of reasons, for all kinds of beneficiaries. A beneficiary who cannot handle money, a special needs beneficiary, minor children. Trust can be used for asset protection purposes. Trust can be very, very effective wealth transfer techniques where you, over time, gift assets into the trust for the benefit of folks named as beneficiaries in that trust down the road. And you are meanwhile removing from your taxable estate all of the assets that you've transferred into that trust, including the growth over time in those assets. And of course, trust can be used for estate tax planning and for all kinds of charitable or philanthropic planning. So the correlation between wealth and whether trust planning is appropriate for you is not really a direct correlation.
Okay. Can you talk a little bit on probate?
Well, probate is a process. It's not, unlike what many people think, a tax. Okay. Probate is a court-supervised administration of your estate under Washington law. Every state has some form of probate. The primary purposes for probate at time of death are, number one, to make sure that asset titling transfers properly from the person who died to the survivors or the beneficiaries. And number two, probate is intended to make sure that creditors who are owed money, who have legal debts that they're entitled to have repaid, get paid. Those are really the two primary purposes historically for probate: proper title transfer and paying creditors.
Washington State real estate taxes. Washington State estate taxes. Can you talk about those, Glenn?
Washington State is one of 16 or 17 states that has a standalone state estate tax. This is a tax that is levied by the state, the Department of Revenue, on the net fair market value of your estate as of date of death. Now, for a married person, that means the net fair market value of the decedent's community property ownership. It doesn't mean 100% of the estate. It means the 50% or the community property that the owner controlled at time of death. Under current law in Washington, every individual can protect a little over $2 million as of the date of their death before Washington state estate taxes will be imposed. If married couples do smart, basic estate tax planning, as a couple, they can protect a little over $4 million in the year 2015 under Washington law.
Wow. The
amount that can be protected, the exclusion amount as it's called, is gradually increasing annually under Washington law. That in a nutshell is how it works.
All right. So for my listeners, giving them advice on how often they should update their estate plan, what would you say?
Well, you maintain your automobile from time to time to make sure it's running properly. With estate planning, it's a little more of a challenge because as long as your planning is current, that is, reflects the goals and circumstances in your life, that planning may survive for a long time and still be valid and still be appropriate for you. We have many clients who begin tweaking and amending, revisiting their estate planning within 6 months of doing the planning initially because events are occurring in their lives, be it a birth or a death or dramatic change in wealth, that impacts the planning they put in place. So each person wants to periodically review their estate planning, maybe once a year, just to make sure it still continues to reflect where they are and what their goals are.
So any special event happens in interim, do that. Otherwise, once a year is a good time to have it checked. As your host, I advise you not to go through the inexpensive way of setting up your estate plan online. Glenn, help me out here.
Yeah, it's like going to Ace Hardware to buy a pair of pliers because you need to have some teeth work done. I mean, it's just, you can try to do it on your own. Susie Orman is a business lady and a very successful one, but she doesn't particularly care about your individual circumstances and your estate planning, nor is she going to be waiting on the other end of the phone when your survivors, your children, your beneficiaries call her to find out what went wrong or to have questions answered. You want to have a relationship with an estate planning attorney who is there to put a proper plan together, there to provide ongoing guidance while you're alive, and there for your surviving spouse or children or other beneficiaries when you're gone, so that things are done the right way.
Makes sense. Got less than a minute really quickly. LLC for real estate. Good idea?
Well, a limited liability company is an asset protection planning tool.
Yes.
And for folks who have rent-paying tenants in numerous rental units, they're operating a business. And in any business, liability can occur through accidents, injuries. And if you hold title to real estate in your own name, everything you own may be subject to a judgment that's returned against you for liability that occurred on the premises of a property you own. If you own the property in a limited liability company, you're controlling, you're limiting, you're compartmentalizing the damage that can be done to the value of the asset in the limited liability company. You are insulating everything else you own, your home, your brokerage account, everything you have.
Great advice. Glenn, thank you so much for joining me again back in studio. Really appreciate it.
My pleasure.
And coming up next in the Money Hour, how buyers should navigate through today's real estate market. Kurt Nystrand with Keller Williams Realty Bellevue, right here at 1150 AM, KKNW, after the short break.